Artificial Intelligence Law and Justice course, session 31. AI in Law and Justice in USA, some examples and points. Let us do a recap of the earlier session. In the last session, we discussed implementation of AI in law and justice in selected countries and gave some examples. We highlighted the well experiences and even some of them are usually common. Moreover, we said in many countries, different institutions including Bar Association and Departments of Justice are developing guidelines or come out with some guidelines and reference materials. In specific, we mentioned that in this session, we will be looking into USA as a case study and then identify some interesting examples and some particular points from that. So let us move into that now. USA, as you all know, is a federal startup where there are states and then within states there are counties. So the counties have their own legal system, judicial system and all. So, one of the Palm Beach County's digital innovation is considered to be a very pioneering one. So, they have deployed courts and clerk's office over the past 5 years by using AI-driven tools, and then this reduced the inefficiency and errors in document processing. So, they came up with a light-out document processing program in much earlier. So, that analyzes, tags, and then indexes document filings. So, this enables to improve the code and other mechanisms easily. So they started with a 2018 pilot program first, and then they trained hundreds of documents on that, and then they audited all the documents that were trained already and organized by the software. So this resulted in mission achieving 98 to 99% accuracy, much better than the human counterparts. So what they did, they used 5 robotic systems or AI systems that equated the workload of 19 human employees. And this resulted in the human employees spending more time on thoughtful works rather than the routine, mundane works which they have to again and again do the same way repeatedly for hours. And this enabled the skill set growth and increased earning potential for those employees. And then in the USA, there are public offices called public defender offices. Who is a public defender? A public defender is an advocate or a legal professional nominated by the court or by the government to defend a person who otherwise lacks means to defend himself or herself or lacks access to the legal system. So public interest is taken care by appointing a public defender who would be serving the cause of the people, who otherwise would have been left without anyone to defend their case or to seek them justice. So, the public defender officers are also using AI tools in USA. For example, the Miami-Dade County Public Defender Office advocates for the AI tools in legal document and then drafting and research, and it's the first one to use AI for attorneys and teams. Often the public defender is a single person, as such the designation may be, but they work in tandem, they work as teams. So the office of the public defender will have various public defenders working either as individuals or as teams to ensure that those who are in prison or those who are seeking legal justice but otherwise unable to pay for the attorney's fee or unable to reach out to the legal system can use their services. In Los Angeles County Public Defender Office, they integrated all the AI tools into a single toolkit, and then they migrated 24 legal systems to cloud-based platforms. What are 20 legacy systems? See, we have computers of different generations, different capacities available. Today's computers are much more sophisticated, much more powerful in terms of processing speed and other parameters than that were there 10 years or even 5 years earlier. But what happens in many institutions, as computers get acquired over a period of time and used for different purposes, some of the systems may not be up to date or some of the system may be verge on becoming obsolete. And lots and lots of data get stored in different categories of such systems. Some of them may be considered as legacy systems or systems that are not of the current generation or that are on the verge of becoming obsolete. So this Public Defender's Office migrated 24 such systems into cloud-based platforms. Now the cloud-based platforms make things much more easily accessible and then much more easy to work or work with them too also. So shifting from the legacy systems which otherwise are obsolete to cloud-based platforms will enable better utilization of AI in such services. So the idea here is that technology's role should be to improve the case outcome, which means that people should not unnecessarily get punished or should not land up in jail for no fault of their own. And then the person who is to be defended or who has to be defended has to be treated with care. So we need to humanize them. And then to do that effectively, in addition to legal expertise, we need lots and lots of data. So a public defender by choice will have to really use troves of data for that purpose. Again, in this case, what they did, they organized the data by person's name, not by case. And then they also looked at the data into human narratives, and then they said, we'll go for alternative treatments or alternative punishments rather than simply sending them to jail or sending them back to jail. So the idea of the public defender office in such cases is to reduce the prison sentence or at least reduce the term of the prison sentence if already awarded. So what can AI do in reducing the incarceration and then predicting recidivism? Recidivism, we have seen enough examples in the past. First of all, AI tools in judicial making can play a major role there. The Tulane University study of AI in over 50,000 convictions in Virginia pointed out that AI scores offenders risk of reoffending, in the sense that whether they will recommit the crime. And then AI advises judges on sentencing option. And then AI helps to correct gender bias and racial bias in judges' decisions. Judges but often decline alternative punishments to defendants of color. So this again is a major issue because the alternative punishments could be either the person is let on bail with some conditions or conditional bail, or a person is left out with electronic surveillance placed under him, in the sense that the person's movements are monitored electronically. So although technically the person is free, he is free from the jail, but his or her movements will be monitored. So then there are alternative punishments. But what this study found out that for people of descendants of color, the AI based or AI enabled system offered certain choices, but then the judges declined to make use of those alternative punishments. The New York Parole Board uses Compass for risk needs assessment. We have seen about Compass earlier. It factors into account education level, age and re-entry plans. And then the studies of AI effectiveness in these matters shows mixed results in various studies in USA. One is that some of them are critical in the sense that some point out that while these systems seem to be efficient and then they are able to deal with large numbers, their efficiency is something that is debatable because their judgment is no better than that of humans. Or put it in other words, human judgment in such cases is as good and preferable than using AI systems for it. Second, some of them are critical of these such studies for the simple reason, like the public study on Compass and some other studies pointed out, the systems are inherently biased or the systems are inherently discriminatory. Similarly, it has also been found that while some systems may seem to be better or may seem to be less biased, what happens is that the decision given by them is something which a judge may not give, because the judge may be more compassionate or judge may take into account some other factors, or going by the findings of the system and then deciding on that basis by the system itself is not a better choice, because some other things are better left to humans than to the systems by themselves. So some are positive, like this study said it corrects gender bias and then racial bias in judges' decisions. So the results are mixed and then it varies from application to application. But question here is that what ethical considerations need to be brought in here? And then how do we assess these systems in terms of ethical parameters? In USA itself, there is a lot of literature on it, there is a lot of debate ongoing in that. as to how do we bring in ethical consideration, how do we ensure that some of the problems associated with PSA, which we have seen in the earlier class, or with examples like compass, can be combated. Of course, there is no final word on these things. There is no final decision on many of these things. But experience shows that over a decade, after many studies, the justice system is convinced that there are really some issues in that and they need to be addressed. Or the blind faith on these systems has come down. And more importantly, frequent use of these systems also results in many studies that are showing the potential for harm or the probable issues with these systems. So, AI roles in reducing jail terms as well as predicting recidivism, resulting is moving to a direction where, although ultimately the role of AI may not get diminished, but then the decision support systems may get better on one hand, and two, the whole idea of predicting recidivism may be something that may not be left fully to AI in future. Then the study which we have now pointed out by Tulane University, it said it scored offenders by risk of reoffending, advised judges on sentencing option. So this is possible, tools, and then final decision made by human judges. But it also said that disproportionate decline in offering alternative punishments. So which means that use of this system is very mixed. AI is often ignored systems for some people, but they also ignored systems that gave of alternative punishments. So in such cases, use of AI should be done with care, or AI should not be the one that should be the primary decision maker. And then the parole based one which we have seen, the state parole board used to compass risk need assessment. This again is a controversial one. It included education level, age at conviction and re-entry plans. University of California Davis did a 4,000 individual letter released on parole from period of 3 years. And then it looked at the documents based on the compass analysis and then the parole decisions. It found that parole was often denied to low risk individuals due to severity of the initial offences. Now what are the initial offences and why this makes a difference? Because the compass gives an undue weightage to the severity of the initial offences. For example, if a person is initially punished for an offence with a specific prison term or more, or some crimes that are classified as severe crimes, then when the same person goes for a release of bail or goes up to apply for a parole, the parole is denied to them, although the overall risk is less. Because of the earlier punishment or the earlier conviction, parole is denied. So which means that the compact software is problematic because it is unduly harsh or unduly discriminating against people who were convicted of a severe crime earlier. Now let us look into a different perspective here. A person who has already committed a severe crime may or may not commit a severe crime in the future. And it is also possible that if person is released on parole, he may come back or he may not even commit a crime. Because we need to look into the human tendency to reform and to repent and to make good or to come to terms with the past. But when undue weightage is given to the past as well as the punishment on the past crime, the potential for refinement and then the potential for person redeeming himself or herself gets reduced. So when parole is denied on these grounds, it only reinforces the faith of the person that the system is inherently discriminatory and the system is biased against himself or herself. So ultimately the risk may be low, but then system twists the things in such a way that even low risk individuals are denied parole. Now the problems with compass has been studied in detail, and then the pro publica investigation. There again they said the algorithm is no better than human judgment, and then the potential bias in compass algorithm is too well known by now. So what are the ethical considerations and human assessment we need to look into? First of all, in such kind of things, we need to have specific guidelines for ethical AI use. And then we need to address the specific case of bias, fairness and accuracy. Then the implementation of AI, we need to look at structures to oversee that, ensuring that they are reliable and then data privacy is mentioned. And then these are the recommendations given by different studies. One way to address is that to work collaboratively, continuously with AI experts and others to take care of ethical issues. Then human judgment should prevail, not AI judgment. And more importantly, we need to look into the identifying unconscious bias. So the human oversight should be the one that should play a major role when it comes to decisions like parole or grant of bail. So the overall findings are access to justice, improving accessibility through AI is a good positive one. And then future applications of AI in the legal system need to be looked into. And then we can look into best practices for courts and administration and try to implement them elsewhere as well. And then if we educate the court staff on generative AI, literacy becomes better and then they are able to use it better. And then we should use AI to generate legal documents better. So what is often called for is justice tech. And then the idea of justice tech is also very similar to what is called as public technology or technology for public or technology for good or inclusive innovation by different terms. But justice tech means need for justice tech is that can use AI tools for furthering the objectives of technology using AI as an effective tool. So the call for justice tech again goes hand in hand with access to justice. So effective access to justice can be done if we develop sufficient tools that can be considered and put to use as justice tech. On the other hand, we looked up something called public defender. But in USA, there is also a civil rights division which is there as part of the government. And then this civil rights division does a lot of things. I mean, it looks into cases of discrimination, potential discrimination, and cases where there has been discrimination already and there. Because civil rights protection also includes protection against discrimination on account of color or age or any undue discrimination. So the Civil Rights Division of the federal government has issued many guides and other documents. For example, the guidance document of 2023 looks into employees using for automated software. So it gives specific guidelines and considerations for to handle this form software, and then it looks into guidelines for AI and disability discrimination in employment. Why? Because in case of employment, disability or physical disablement could be a criteria that may go against many people who otherwise would be qualified. Under the US Act or under the US legal system, using disability as a factor to discriminate is an offense. And then Civil Rights Division can step in and try to settle this matter by suing against an employer or a potential employer who use this idea of disability as a discriminating factor. So this guidance looks at how AI can lead to disability discrimination in hiring, or it identifies the ways AI can result in hiring on account of discrimination. Then the Civil Rights in Digital Age did publish an article and then said, look, these are the major issues which the federal employees in the employment administration has to take into account. Then it also looked into what the Department of Justice and other agencies are working at it. In the subsequent slides, we will look at some of the instances where Civil Rights Division has effectively intervened and then tried to get justice to combat discrimination. The Department of Justice Technical Assistant document dated 2022, title Algorithms, Artificial Intelligence and Disability Discrimination Hiring, describes how algorithms in AI can lead to disability in discrimination and hiring. So it is alerting the employees or it is alerting its own staff and others like there is a significant potential or there is a possibility of AI being used to discriminate on account of disability. So the idea of civil rights in digital age looks at the impact of AI on employment practices, predominant issues on that, and then what is the work being done where by different federal agencies. And then there are some cases where we will look into. The Robocalls and Voting Rights Act. Robocalls is nothing but automated call in the sense that you get a call on your phone number by automated call system that talks to you immediately and then collects some information or asks for your response. In such a case, the Civil Rights Division filed a statement supporting private plaintiffs who said that or they were discriminated by the robocalls. Because it said the robocalls were coercive. We will see the details on that. In Fair Housing Act and Tenant Screening, it filed a suit of motion in St. Louis against a tenancy leasing firm called Sapphire Rent et al. It said their pattern or their practice discriminated against black and Hispanic applicants. The sense that they used AI to screen applications. Then it went to a specific instance in California, Berkeley, where it said that California, Berkeley's online content was not available to some selected stakeholders and that itself constituted a case of discrimination. And then Meta platforms, there were issues on housing advertisements for hiring. So it went into job description advertisements. Then Microsoft citizenship status discrimination, and then Health Alliance investigation. So we will these things in little detail now. In the robocalls, the justice system went to a statement of interest and then went to District Court of Hampshire. It said that the AI generated robocalls were in fact are known as deepfake robocalls because they threatened, they intimidated, and then they made coercion on the people who were on the other end. So it said it violated Section 11B of the Voting Rights Act. So the idea here is that people should not get intimidated or should not get coerced or should not be non-voluntarily forced to disclose information which otherwise they would not be disclosing. In the case of Department of Justice and the Department of Housing and Urban Development, they went to a specific instance where the Safe Rent et al. Is a company and then which is formerly called as Core Logic Rental Property Solutions. It used a algorithm based tenant screening. Now the tenants are screened by these systems based upon some parameters including whether they are people of color and then other things including their citizenship criteria and all. So it found that the AI based algorithm based system discriminated against black and Hispanic rental applications and then discriminated them particularly in instances where they were using federally founded house vouchers, house choice vouchers. See, the federally founded house choice vouchers are made available to poor and then some sort of tenants who otherwise would not be able to pick up certain houses which are unaffordable to them. So using those vouchers, they will be able to pay the rent or at least bid for those houses where they can go as a tenant. Then it said this action by this algorithmic based tenant screening system violated the Fair Housing Act as well as the Massachusetts state laws. So it found that using of algorithm based tenant screening system was prima facie an algorithm based discrimination against specific people of black and Hispanic origin, particularly when they came for rental applications. So such use of discrimination, identifying them and then suing against that by way of identifying the specific provisions indicates that while discrimination is not novel, what is novel is the use of AI based algorithmic decision making. So the law has to keep up with that and then the agencies have to keep up with that to ensure that these discrimination which are sophisticated technologically being used do not survive or do not continue even in this age. So what is happening is that some of the earlier ideas or earlier provisions like fair housing or the right of the voting rights of the people, when they are getting negated in part or in full on account of various AI based strategies including deepfake calls and then AI based systems based on faulty algorithms, agencies have to step in to ensure that the civil rights are protected and then there is no discrimination. So in the case of University of California, Berkeley, the Civil Rights Division stepped in and then said the online content was made available by the university is inaccessible for people with disabilities. People with disabilities here obviously mean people who are not able to see or who are not able to hear. Often you would find these days that many of the websites enable you to hear or by voice, we give you the option to hear them rather than to see. And many websites have the options for visually disabled people to increase the length or to access the site otherwise. So it said inaccurate automated captioning for hearing impairments was not valid. So it got a decree approved on that, and then it said university has to provide accurate captions and not rely solely on YouTube's AI based technology. Mark the point here. It said it is the duty of the university to provide accurate caption there instead of relying on the technology developed by AI by YouTube for use of AI. So it said prima facie, it is the responsibility of the university in this context to ensure that the captions are accurate and are accessible to people with disabilities. In Meta platform case, the case got settled in its favor. In June 22, the Civil Rights Division and the US Attorney for Southern District of New York jointly filed a case. They said that there were some issues with the Meta platforms, and then they entered into a settlement agreement in June 22, and that was finalized by June 27, 2022. What is the case here? So in June 22, the initial round of settlement, when Meta platforms advertisements are posted on college and online recruitment platforms, including Georgia Tech's platforms, it said the advertisements discriminated against non-US citizens. Here, the point is, even if the advertisement discriminates against non-US, the Civil Rights Division is ready to step in and then tell that this is a blatant case of discrimination and violence of Equal Rights Act. So what happened in this case was, it went to the employers using recruitment platforms. First, some of the cases were that it went to Microsoft Corporation, received claims of discrimination based on discrimination citizenship status. It said Microsoft unfair documentary practices were discriminatory. It used employment eligibility criteria improperly to verify the citizenship, and then it went biased against the non-US citizens. Then the case with Ascension Health Alliance, it said the practices in the employment verification were unfair documentary, and then the documentary was improper programming was there because it sent email verifications unnecessary, which were unnecessary prima facie, to non-US citizens, or non-US citizens were harassed by the emails which they should not have been received in the first place itself. So the Immigration Nationality Act's anti-discrimination provisions prohibit requiring more than different documents necessary is prohibited, or seeking unnecessary documents, seeking unnecessary documentation, and then evidence itself amounts to a act of discrimination. Then discrimination based on citizenship, immigration status, or natural origin itself is a discrimination. So when these factors are used to discriminate against by different entities through different platforms, the Civil Rights Division stepped in and then found that these violations cannot be acceptable, and then they violated the federal laws, particularly the Immigration and Nationality Act. So the various guidelines which the Civil Rights Division came was, you need to collaborate with experts, 5 judges and a lawyer and a computer science professor should be there to work on the groups of AI and the courts. Then you need to look into purpose of the American Bar Association Task Force on Law and Artificial Intelligence, and then the consensus working group of the working group members. So the idea here is that these provide a framework of responsible AI use and then use at the judicial officers. So the purpose of different guidelines is to move towards responsible AI deployment in law and justice, particularly on account of the various expertise being necessary there rather than simply relying on computer scientists or data scientists. So the judicial authority and AI, judicial authority should be independent, competent, impartial and ethical, and then it should be solely vested with judicial authority. This is what the guidelines say, and not with the AI systems. And then technological advances, the Civil Rights Division and then other federal agencies are willing to work with the various entities to provide new tools to assist the judiciary. But the core obligations is to provide, maintain professional competence, uphold rule of law and then promote justice. So the judicial integrity, what exactly the IA can do? First and foremost, IA should strengthen but not compromise on judicial integrity. And then judicial officers must remain impartial to ensure public confidence. In the sense that they should not unduly overtly rely on AI, and then their behavior and use of AI systems should ensure that they look impartial and then they are also impartial so that public confidence is maintained. And then they are solely responsible for their decisions. So they need to know, they need to get to come to grips with and then understand how the AI tools work. And more importantly, they should know that if they are going to use any extrajudicial information from AI, then there is a risk of relying on that. So they should decipher as to what information AI is providing them and whether it is really necessary. If you are relying on extrajudicial information from AI, you may end up having a risk or giving a judgment that may not be correct. So how do we balance AI's principles and promise with the core principles of judiciary? So AI can produce increase advanced justice, but don't over rely on AI. And then judicial officers ensure that AI enhances their responsibility, but AI cannot be held responsible. They cannot substitute their responsibility by using AI tools, nor can they assign their responsibility to AI tools. Having said, we need to look into the limitation of Gen AI. Gen AI content based on prompts and training data. Now this again we have seen that how do you give the prompt often decides what the outcome could be the potential one. So this is again an issue when it comes to Gen AI tools. If the prompt gives a decision, gives a hint, if the prompt itself is taken as a hint and then the answer is tailored to that. So the training data and the prompt also make a difference. So the judges should be aware of this and should know what exactly they should ask when they use Gen AI tools, or they should know the limitations of using the wrong prompts or the prompts can be misleading. And judges should know that Gen AI does not engage in traditional reading, reasoning or exercise judgment. So they should know what are the biases there and avoid becoming anchored to automated information they should be aware of. They should also account for the confirmation bias. And then they may need to disclose AI use under local rules. And more importantly, they should be there under obligation to prevent ex parte communication, in the sense that communication to the party without the other party being aware or using the AI tools wrongly and then sending ex parte communication should be avoided. More importantly, the work product materials produced in their name should be verified from them. Or when AI gives an output in their name or the work product used obtained using AI should be verified and checked by them. Then Gen AI tools prompts may be used to train models further. So what happens, this is an important point. If I am a judge and if I am using Gen AI tools effectively again and again, the data or the prompts which I am using in the Gen AI tools may be used by the developer to train subsequent models. And then this information may get sold or shared with a third party developer or to another party. So it is important for the judge or the judicial officer not to specifically identify himself or herself when they use prompts. For example, the prompt should be something where the privacy or the identity of the person who is using prompt is not disclosed. And then the information should also be not disclosed. Suppose if I am a judicial officer, by mistake I give the prompt where unknowing to me or knowingly I display my role and then my designation and my name, or I say I am a county judge asking you this, then the prompt will address me as county judge of this that county and then will give me the output or the decision or whatever I want from it. So some sort of this information should be kept confidential. And then the judicial officers or the judicial team should not use health data or privileged information in prompts. This is important because health data is very critical, something very fundamental. So I should not give a prompt and then say, an accused before me, so and so, is suffering from this and then wants bail on that ground, or is wanting some concession for me on that health ground. So the moment I give these details, Chat GPT or any other AI tool will give me the answers. But then I am unknowingly or knowingly destroying a privacy related health data. So since the tools may treat data in a very casual way, that data may be used for training purposes, or the data may be again used to some other data set and then may go somewhere else. So this sort of confidential information sharing should be avoided. So look at the tool setting, look at what exactly are the prompts, and then whether the prompt history should be made available or should be there in the memory after the session should be taken into account. As a good practice, it is better to disable and then delete the prompt history after sessions irrespective of the AI tool you are using, because knowingly or unknowingly you might have given some information which otherwise you would not have given, and then the prompting sessions may be using the promptings which you gave or the sentences or your own inputs to train the system further. And then comes the question of quality and reliability of Gen AI. So this again is an area where we have discussed much earlier, so we won't go into greater details here. So AI and Gen AI tools can be used in core systems to assist time and workload studies, and then they can use unofficial preliminary transcription in real time, which again we all know that most of the conference tools like WebEx, Teams, they also have now inbuilt tools that give you the summary or that give you the updated recording or the synopsis of the sessions. So real-time transcription is also possible through them. Then of course for foreign language documents they also give translations, and then they can also analyze data, routine, administrative workflow, and then go for suggest efficiency improvements, and then they can be used to organize and managing documents. So in case of operational data analysis in USA, Gen AI tools are using very extensively. Then of course editing and proofreading, which many of us may not be using AI extensively, but that again is a good potential use for judges and then judicial officers. And then how to implement this? Reflect the technological advances, incorporating emerging best practices and gen usage, and then usage alone is not the sufficient thing. You need to look at validity and reliability of the tools you are using. So the situation as of February 25 or as of that, the summary, the studies which were done on US application of AI in law and justice mentioned, no Gen AI tools have fully resolved the illustration problems. So it remains still there. So human verification of Gen AI and AI outputs is essential. Some tools perform better than others, but still there are a lot of issues with many tools that are used in law and justice. So how to get started? This is what the manuals which state. Evaluate the benefits, review the legal and ethical considerations, look at the low risk task, and then go a human in the loop approach, human oversight to ensure accuracy, train staff and other systems, and then prepared for advanced tasks. When you graduate from a low risk task, you go to advanced tasks and then engage in knowledge sharing. See, these are available in the literature which I have cited, although I have not specified in which letter this is available. So for further details, you can go to the literature and find out. Now, there are two ways of judicial thing. One is accusatory versus inquisitorial. Accusatory is the common law principle. It's used in the USA, where two autonomous equal parties, party A file a case against party B, and then they suspect, and then there's a prosecuting party, or it is state versus me or me versus state. So there are only two parties, either private versus private or state versus private or private versus state. And then each party brings its own case and then argues before a federal or a neutral judge. So the adverse accusatory model is that I accusate or I accuse or you are accused. So this is where a neutral judge has to act as a balanced and then listen to both parties and then come to the judgment. Whereas in the inquisitorial mode in civil law, particularly this is the culture in Europe cases, official authority collects evidence independently. And then the evidence is used to uncover truth without consulting any party. So in the inquisitorial mode, the authority acts as an inquisitor. Inquisitor is one who probes, who puts questions and questions, or who is there to punish or to find the potential for punishment. So the authority collects independent evidence independent of the party. Now why are we discussing it? We will come to in a bit. Now exclusion and relevance of AI in output, this is again very important. We need to create into something that is deemed relevant. Federal relevance for evidence has to be assessed first. Enhancement and augmentation of low quality footage has to be avoided. Significant modification should be done. Creation of new content may be slow, but what really happened had to be looked into. Relevance may be questioned if AI fails to show actual events. So this comes when you use AI evidence, particularly the visual and audio visual evidence as evidence. So in USA, different states have their own different policies, and then how the systems are being used also varies from different courts. California 2024 rules of court says risk assessment technology, some standards have been met, and these are used specifically for sentencing purposes. And then risk assessment impacts the right to privacy has to be taken into account. Then in the adversarial system, we can use AI in the court, where the AI, if it is used there, the AI evidence can be challenged, and then this ensures fair trial. So the federal rules on evidence have been updated to address AI based or AI generated evidence, and then this improves judicial gatekeeping. And then the 2023 amendments to Federal Rule of Evidence 702 and then the 2024 AI policy have to be taken into account. Or now the human experts to understand AI have got updated guidance and then guidance principle notes available to them. So the legal frameworks are also already there, necessary for accurate in criminal procedure. Privacy concerns need to be looked into, data privacy, integrity, quality. This again we have discussed so many terms earlier. So the broadened ex ante regulation approach is also now emerging. In this, AI usage should be comprehensible and scrutinable by human judges. So here, AI should not be used in critical decisions. And then critical decisions need adequate and concrete reasons. First, the judge should decide as to whether he is going to use AI, he or she. And if has to decided, then there has to be justified with adequate and concrete reason. Then AI can be used where statistical precision is required in greater detail, where there is no human rights law at stake, or this is a typical commercial transaction, or where the matter is more of data crunching than of violating any privacy or violating any human rights. Then AI should corroborate human made decisions here, and then the performance should be subjected to enhanced checks and balances. So in appellate 2025, the Trump administration came up with new AI guidelines that were applicable for all federal agencies, which said keep minimum risk management practices, reduce vendor lock-in, improve transparency, and then protect IP and public data. These are applicable for AI systems used in the judicial systems in USA. So with this, we have seen a good example of, or many examples of, how AI is being used in the US in different levels, and then why there is so much of variance available, and why the views on Compass itself are not concurring with each other. And more importantly, we also looked into and found that some of the tools in USA, although are controversial, they are similar tools are being used extensively, particularly in criminal justice for decisions on parole or bail. So we can conclude a few things here safely, although these are very preliminary hypotheses. One, Civil Rights Division and then other institutions in USA are now better equipped to handle with cases that are using based on AI discrimination, and they are updating themselves to handle such cases. Point number two is that irrespective of the wide variance, most of the courts or most of the institutions are moving towards more use of AI and to facilitate that, many guidelines, including bar association guidelines, guidelines by federal agencies, guidelines by port counties, and then everything are given there. Some of the evidences or some of the literature which I have cited specifically give some good examples on that. For example, the AA Rapid Response Team, National Center for Stat Codes, or the one which is given there as Navigating AA in Judiciary, New Guidelines for Judges and their Chambers, which is forthcoming in 2025, deal with these things in greater detail. So, USA prima facie seems to be progressively addressing some of the concerns associated particularly with AI or discrimination on and then bias, to ensure that some of the civil rights are defended and some of the human rights are protected, and more importantly the institutions are up to date with dealing with AI in law and justice. Or in other words, since we are dealing with responsible AI in law and justice, such a topic needs a large amount of good literature survey and then good practices that need to be picked up from different jurisdictions and different countries, and then also look at what people have done in right, what people have not done in right, and the specific context. Only we contextualize them, only we will be able to identify what are the major issues in putting responsible AI to use in law and justice, and more importantly in the Indian context. So with this we are completing the discussion on responsible AI in law and justice. We have seen examples, we have seen the specific fundamental principles, we have gone into the general issues in law and justice when it comes to responsible AI, and then we have done 2 sessions on use of AI, particularly in law and justice in 2 sessions. So our discussions by now, including responsible AI, ethical AI, evidence of explainable AI, and then use of AI in law and justice, would have given you adequately a good overview and idea of the some of the key issues on using AI in law and justice. Of course, related to responsible AI, again related to explainable AI. But overall picture is that lot of things are happening, lot of important developments are happening, and we need to keep our eyes and ears and mind open to learn from all these things and to pick up what is more relevant to us. The next thing will be something very a logical sequence to that, that is AI and judges. There where we will look into some of the things which we have discussed earlier as to how different institutions are coming to grips with use of AI in law and justice. Thank you.